In the complex and often unforgiving world of India's criminal justice system, two words offer a sliver of hope to those behind bars: parole and furlough. They are often used interchangeably in conversation, but for a prisoner and their family, the distinction is a world apart. Both represent temporary release. Neither is a pardon, neither is an acquittal. They are not rights to demand, but privileges the state may grant. These mechanisms acknowledge that even a convicted person remains a human being with familial and social ties. They are a son, a daughter, a parent, a spouse. Life, with emergencies and solemn duties, continues outside prison walls. This is not about letting criminals walk free. It is about balancing punishment, reform, and basic human dignity. Amid rhetoric and headlines, parole and furlough are structured responses tested against public safety. Parole is not a holiday. It is a continuation of the sentence outside prison under strict supervision. Its purpose is reformative, a test of readiness to reintegrate as a law-abiding citizen. Parole comes after a substantial part of the sentence is served. The state bets on change, with stringent conditions for safety. Parole lasts longer than furlough, often weeks, sometimes months. That time helps reconnect with family and possibly secure employment, critical to preventing relapse. A parole board, comprising judicial officers, prison authorities, and sometimes social workers, reviews conduct, the crime's nature, police and psychologist reports. Serious categories like terrorism, multiple murders, or offenses against the state are often excluded. Parolees must report regularly, follow curfews, and stay within set areas. Non-compliance triggers immediate return and potential penalties. Parole is a privilege, not an entitlement. If parole is a chapter in reformation, furlough is a brief footnote, planned short-term release, typically a few days to a couple of weeks, granted periodically to long-term prisoners with good conduct. Grounds include family weddings, property matters, or time with aging parents. Decisions are administrative, recommended by the superintendent and approved by senior prison officials, with police input. Leave has exact start and surrender times. Delay without valid reason is a serious violation. Emergency release covers unplanned humanitarian crises, critical illness of a close relative, a death in the family, or urgent medical treatment unavailable in prison. Authorities may act swiftly, granting very short-term escorted leave to address the immediate crisis. In Asfaq versus State of Rajasthan, the Supreme Court clarified the distinct purposes of parole and furlough and insisted on fair, non-arbitrary consideration. Poonam Lada held that parole is not a suspension of sentence, but a conditional release tied to discipline and reform. During COVID-19, the court directed interim paroles furloughs to protect health while preserving security. The power to grant temporary reprieve follows a clear hierarchy of decision-making. Parole, a multidisciplinary, quasi-judicial board assesses files, reports, and risk before supervised community release. Furlough, internal administrative process within prisons focused on management and mental well-being. Courts usually do not grant day-to-day releases, but intervene when decisions are arbitrary, discriminatory, or breach procedure. Rejected applicants may file writs. Courts ensure the process remains fair, just, and non-discriminatory. In extreme medical emergencies, courts can direct emergency medical parole or furlough when executive action lags. Sunil Batra reinforced humane treatment obligations, contextual backbone for temporary release jurisprudence. State prison manuals govern granular eligibility. Courts read them with constitutional fairness. Gatekeepers, administrative and judicial, must turn the keys with caution and conscience. Temporary freedom is not absolute freedom. Both come with non-negotiable conditions to ensure good behavior and public safety. The fundamental rule: return on time. Failure can cancel leave and trigger a new criminal case. Residence at a verified address. Police verify before release. Movement limits and periodic reporting, daily or weekly, enable constant oversight. Restrictions may forbid contact with victims, visiting certain places, or associating with known criminals. Some cases require surety bonds from friends or family. Violations can forfeit the pledged amount. Electronic monitoring adds another layer of control where available. Courts ensure conditions are strict but reasonable, not arbitrary or impossible to fulfill. Overbroad bans, like prohibiting any family contact, can be curtailed by judicial oversight. Parole and furlough mark a mature system, moving beyond pure punishment to recognize reform and dignity. The aim remains public safety, achieved by structured, supervised reintegration, not sudden release. Every rule and condition seeks equilibrium between mercy and security. Failures make news and spur stricter calls, but thousands of quiet successes go unreported. A parent returns for a child's wedding and goes back on time. Families reconnect. Skills lead to lawful work. For students of Indian law, this topic is a microcosm of punishment, forgiveness, risk, and reform. Public safety is non-negotiable, yet the door to mercy and second chances must remain open. A just system knows when to punish, and when, prudently and temporarily, to let someone prove they can do better.